Thank you very much, Alex. This final session we've called Best of the Rest, and it's a roundup of three particular developments of interest from 2011. The first case that I'd like to look at is that of Porton Capital and 3M UK, which consider the implications of the use of the expression consent not to be unreasonably withheld in a commercial contract. This is a commonly used expression in commercial contracts as well as in, say, leases between landlord and tenant. But in fact, most of the previous cases providing guidance on its meaning have tended to be landlord and tenant cases, probably because the situations in which it's used in leases are relatively limited and so provide more direct precedents for other leases, consent to an assignment or consent to a subletting and so on. Whereas in commercial contracts, the situations in which the expression might be used are absolutely myriad. The Porton Capital and 3M case confirmed that the principles derived from those previous landlord and tenant cases are applicable to commercial contracts. This is handy because not only are there a lot of those cases, but also the principles have been pulled together in a couple of landlord and tenant cases. Probably the best summary being in International Drilling Fluids and Louisville Investments from 1986. So what I'm going to do is to run through those principles in their original landlord and tenant context and then apply them to commercial contracts. The International Drilling Fluids case, by the way, concerned a landlord's consent to an assignment. First, the burden of proving that consent has been unreasonably withheld is on the tenant. So in a commercial contract, we can confidently say that the burden of proving that consent has been unreasonably withheld is on the party seeking that consent. Although, of course, it's open to the parties to reverse that burden and expressly agree in the contract that the person refusing consent must show that it's done so reasonably. Next, the landlord does not have to prove that the reasons why he withheld his consent were justified, as long as they were reasons which might have caused a reasonable man to reach the same decision. This principle can also be directly translated into a commercial contract. And in this context, it's relevant to note that the party is entitled to take into consideration what is likely to happen, as well as what will necessarily happen if he consents. So although the test of reasonableness is objective, the court will look at it in the context of the considerations of the particular party who is withholding consent. Next, while a landlord need usually only consider his own relevant interests, there may be cases where the difference between the benefit of the landlord and the detriment to the tenant, if the landlord withholds his consent, is so disproportionate that it's unreasonable for the landlord to refuse consent. That principle can also be directly translated into a commercial contract. So, to provide an extreme example, if on the refusal of consent the party withholding its consent will gain £1 and the other party will lose £1 million, then if that £1 benefit was really the only reason for withholding consent, it's likely to be unreasonable. Next, a landlord is not entitled to refuse his consent to an assignment on grounds which have nothing to do with the landlord-tenant relationship with regard to the subject matter of the lease. This principle is harder to apply in a commercial contract, where there may well be a wide range of reasons which the party withholding its consent may wish to take into account outside of the specific contractual relationship or the subject matter of the contract, which it would regard as relevant to its wider interests. However, the British Gas Trading and Eastern Electricity case provides a good illustration of the application of this principle in a commercial contract, where British Gas was undergoing a restructuring, and if its gas supply contract wasn't assigned, then the resulting change of control of British Gas would entitle Eastern Electricity, the customer, to terminate the contract. So Eastern Electricity tried to withhold its consent to the assignment, purely for the commercial advantage of being able to terminate the contract. The court said, "There's nothing objectively reasonable about Eastern's attempt. In my judgment, Eastern are not entitled to contrive that British Gas should remain unwilling parties to the contract so that Eastern may terminate it. To achieve that result is not a reasonable ground for withholding consent to the transfer of the contract to an otherwise unexceptionable transferee." Finally, subject to the above principles, it's in each case a question of fact, depending on all the circumstances, whether the landlord's consent to an assignment is being unreasonably withheld, and that principle, of course, can also be directly translated into a commercial contract. So what happened in the Porton Capital 3M case? Here, 3M bought the shares in a business called Acolyte from Porton Capital. The share consideration included an earn-out element based on future sales of Acolyte's sole product, which was an MRSA detection technology called Backlight. To protect the earn-out, 3M agreed not to stop the development and marketing of Backlight without the seller's consent. such consent not to be unreasonably withheld. Backlight, though, proved unsuccessful, and after a year, 3M asked the sellers for consent to stop developing and marketing the product, claiming that the market had moved, the product had failed, and there was no prospect of product sales generating any additional payments to the sellers. The sellers refused to grant their consent, arguing in effect that 3M couldn't be certain that the product wouldn't sell, that 3M's own conduct of the business had contributed to the decline in sales, and anyway they didn't see why they should consent to forfeiting any prospect of their potential earn-out. The court applied the principles we've just looked at and said that, first, the burden was on 3M to show that the seller's refusal to consent to the closing of the backlight business was unreasonable. Second, the sellers didn't have to show that their refusal of consent was right or justified, simply that it was reasonable in the circumstances. Third, in determining what was reasonable, the sellers were entitled to have regard to their own interests in earning as large an earn-out payment based on backlight product sales as possible. And finally, the sellers were not required to balance their own interests with those of 3M or to have regard to the costs that 3M might be incurring in connection with the ongoing business of backlight. So, as you can probably tell, the court found that the seller's consent had been reasonably withheld. Now, Porton Capital and 3M isn't the first case to say that the principles developed in the landlord and tenant cases apply to commercial contracts. And you can see pretty much the same approach in, say, the British Gas Trading and Eastern Electricity case that we've looked at. But Porton Capital is a good case both for an analysis of the principles and as a reminder that when we're looking for examples of the application of the relevant principles in previous cases, we shouldn't ignore those landlord and tenant cases, and indeed we're probably more likely to find the answer there than in most other places. Next, the issue of deliberate repudiatory breach, and the question as to whether a party in deliberate breach of contract can still rely on the terms of that contract to limit its liability. The answer is that it is in fact perfectly possible for a party to limit its liabilities for its own deliberate breach of contract, but the contract needs to be crystal clear that this is the case, because the courts are going to require some convincing that this is what the parties actually intended. If one party is dealing on its standard terms, then any such liability exclusion is going to have to satisfy the reasonableness test in the Unfair Contract Terms Act anyway, and that's going to be a tough call for an exclusion of liability for a deliberate breach of contract. But, on the other hand, if the parties have specifically negotiated and clearly agreed the relevant provision, then the courts have accepted that there's no general legal principle which prevents a party from, as it were, avoiding the financial consequences of its own wrong, and such a provision can be enforceable. This was illustrated in the case in 2009 of Internet Broadcasting Corporation, known as NetTV, and MAR, which concerned an agreement which, under its terms, couldn't be terminated for 3 years, other than for an unremedied material breach. Despite this, and for reasons which were not clear in court, MAR gave notice purporting to terminate the agreement with immediate effect and stop performing its obligations under the contract. This has amounted to what's called a deliberate repudiation of the contract by MAR. In other words, it walked away from the contract in circumstances which it actually accepted in court was a contractually unjustified action. But MAR then sought to rely on an exclusion clause in the contract to avoid liability for NetTV's loss of profits arising from that wrongful repudiation. The court said that there is a rebuttable presumption that an exclusion clause cannot be relied on where there's been a deliberate repudiatory breach of contract. The starting position is a presumption that a party which repudiates its contractual obligations will be liable to compensate the other party for the resulting loss. But this presumption can be rebutted by the construction of the exclusion clause. However, in the case I'm going to look at, AstraZeneca and Albemarle last year, the court disagreed with the NetTV approach of a rebuttable presumption that an exclusion clause doesn't exclude liability for a deliberate repudiatory breach. In AstraZeneca, the court said that there's no need to superimpose this presumption onto the general principle that the courts will construe an exclusion clause strictly against the party seeking to rely on it. And further, that in construing an exclusion clause against the party which relies on it, the courts will strain against a construction which renders that party's obligation under the contract no more than a statement of intent, and won't reach that conclusion unless no other conclusion is possible. Where another construction is available, which doesn't have the effect of rendering the party's obligation no more than a statement of intent, the courts should lean towards that alternative construction. So in a commercial context, the courts are clearly hostile to a clause that would leave an innocent party without a substantive remedy. And because financial considerations, generating revenues, making profits, whatever, underpin most commercial contracts, The use of an exclusion clause which seeks to exclude all heads of financial loss should be carefully considered as to whether it will in fact result in the innocent party being left with no meaningful remedy in the event of a breach, and hence be ineffective. As a secondary point, there was some concern after the Net TV case that exclusion clauses may need to be redrafted to deal specifically with a deliberate repudiatory breach, although in fact that wasn't a practice that we ever adopted. And in fact the AstraZeneca and Albemarle case has confirmed that such redrafting is not necessary. Whether or not there is a deliberate repudiatory breach of contract, one simply construes the relevant exclusion clause strictly, but without starting from any presumption or special consideration.